Mr. Director, thank you for being here today. You mentioned in your testimony that your office is actively working to address the current inventory of applications that are awaiting review, and I think the number's been set at approximately 540,000. Can you update the committee on what you're doing to ensure that pending applications can be reviewed in a more expedited time frame?
Sure. Yes, the backlog is a bit over 500,000 approximately. We always have to balance the backlog and dependency times against the quality, obviously, and the resources that we have at the office, and we watch that very carefully. We want to make sure we have the appropriate number of examiners on staff to be able to review in a timely fashion, and that they're appropriately trained to provide the highest quality during that review. We are currently engaged in an examination time analysis, an analysis of the overall time given to each individual examiner or groups of examiners to review patent applications. And we are looking forward in the near term to making some changes that would optimize that time allocation even further.
You've stated that the Patent and Trademark Office is looking for ways to simplify patent eligibility determinations through the new examiner guidance, and I know you may have covered this. We're coming in and out because we all have different meetings, but weeks ago, of course, the PTO issued new examiner guidance focused on how examiners are to document a finding that a claim is old or conventional. And you may have covered some of this already, but just briefly, what are the plans you have to change how the PTO determines whether the invention is patent eligible?
So the guidelines, the guidance we have provided a few weeks ago deal with the second step, the conventionality part of the analysis. They address how an examiner is to document it and actually what it means. On a going forward basis, we are also trying to address through guidance what the other parts of the ALICE framework mean or how they should be applied by the examiners, such as what's an abstract idea, for example, what does directed to mean, and things of that sort. It's not a simple issue, and there are a lot of competing issues, obviously, and we have to be very careful to have a balanced approach.
I appreciate that. You had a dialogue with Congressman King a few moments ago. You were talking about our place in the world, so to speak, and in your testimony you mentioned how the American Invents Act has taken significant steps to harmonize the U.S. patent system with many of our trading partners overseas, and you talked about how you've been working with stakeholders across the industry and the world to better harmonize patent law among all these countries. So can you give us just a quick update on how that's going and what those efforts look like?
Sure. So the AIA provided one major piece of one major step towards harmonization with the first to file system. There are other efforts primarily driven by industry regarding the harmonization of prior art, for example, and other such issues. So we are meeting in international forums where both various patent offices from various countries, as well as industry groups from various countries, we're meeting independently and together to address some of those issues. There is a meeting coming up, actually, of IP5 in Louisiana, in New Orleans, just next month. That's the top 5 IP offices in the world, and we will address harmonization there as well.
We have a lot of intellectual capital in Louisiana, I just want you to know, and thank you for coming. Look, as a conservative, and many of us agree that we believe that the protection of individual property rights and intellectual property as well is essential to who we are as Americans. So I appreciate your efforts in that regard, and I hope as we harmonize this with other countries around the world, we can share this idea about inalienable rights and why this is so important to who we are, not only as Americans, but as human beings. So I appreciate it.